Welcome to the Risk Advisor Podcast extended version. I'm Sal Lafreri, and I'm here with Helen Rella from Wilk Auslander. Hopefully I got that right.
Yes.
Okay, we got that right. We got the first part of this down. Helen, thanks for being with us.
Thank you for having me.
Good to have you here. Okay, so during the course of the podcast, we talked pretty extensively about some of the questions that you're getting from clients, some of the issues that they're dealing with. What is it that you're predominantly hearing from clients today?
The biggest issue that we hear today in the wake of the coronavirus pandemic pertains now in returning to work, because at this point in time, New York City in particular is in phase 2 of the reopening, which includes professional offices. And the issue that is being raised is whether or not employees are going to be actually going back to work. There are a lot of reports that we see that show that employees themselves don't want to go back, and in fact, in large cases, are refusing to go back. And it's because of fear. But unfortunately, fear is not an excuse that justifies an employee refusing to go back to work when the employer makes a decision to go ahead and reopen the workplace in accordance with the governmental regulations that permit the offices to now reopen.
So as we were talking about in the show, Jim and I have been spending a lot of time going over reoccupying plans, with the social distancing for corporations, how we get access controls into commercial buildings where now we have all of these other requirements and things that's coming up. Today, people are working from home. A larger proportion of people are working from home. That's got to produce issues that who's paying for those costs? Or do the employers have any obligations?
Under the law, there is no obligation for an employer to pick up the cost of employees working from home. The employer sets the terms and conditions of employment, and that includes where the work takes place. So if an employer is permitting an employee to work from home, the costs associated with that are borne by the employee unless there's an agreement between the employer and the employer to the contrary. And certainly we would encourage anybody who has those concerns to raise them. And many employers have been accommodating in assisting in picking up costs and providing employees with laptops, for example, if they're working from home, cell phones that they have from the office, routing calls from the office to their cell phones. So there's a cooperative exchange that's going on, but there is no actual affirmative obligation under the law.
What about underlying medical conditions? If somebody has a specific medical condition and there's an actual concern about coming back to the workplace?
Well, that's the one area where employees have a little bit of a leg up on their employers, because the employee is able to ask for an accommodation under the law. If you fall within the category of somebody who has what we've heard the physicians who are commenting on COVID-19 speaking about, a comorbidity such as an underlying lung condition, heart condition, high blood pressure, asthma is a lung condition that we hear people talk about, and people who are 60 or over are considered to be at a higher risk with respect to the virus. So those employees can make a request to their employer for what's called a reasonable accommodation under the Americans with Disabilities Act. And the employer must consider those requests in an even-handed, non-discriminatory manner.
We're seeing a lot of confusion apparently between CDC coming out, and then you have the state guidelines, and then you have the city guidelines here in New York.
Right.
What's in general, what's the return to work guidelines, and what should you be guided by?
Unfortunately, employers have to look at all of the guidelines. The guidelines themselves pertain to the employer, largely with regard to safety and hygiene in the workplace. The CDC guidelines deal with testing and suggesting that people remain home, and an interplay with the Department of Health and requiring people to quarantine after they've had a diagnosis of the virus. And the state guidelines, the ones that Governor Cuomo in New York has issued, and guidelines that the governors of various states throughout the United States have issued, come in the form of both mandatory and recommended guidelines. The Phase 2 guidelines in New York with regard to the professional offices opening have a total of 60 mandatory and recommended guidelines that offices have to follow. And they deal largely with the provision of PPE, social distancing, sanitizing of the workforce, those issues in order to try to ensure that the virus doesn't come back.
We know, again, Jim and I have been spending a lot of time with clients talking about temperature testing and things like that, then there's a tremendous amount of confusion that that presents itself from the technology side of it. But separate and apart from the technology, what would be your concerns? What would be your thoughts about temperature testing? What issues does that bring up that employees have to be concerned about?
Well, the temperature testing is a landmine issue, and that's largely because there's inequality in the systems that are out there. There are very few technology companies that employ temperature testing criterion that actually ensure that there's a degree of accuracy that's reliable. The thermal imaging, the infrared thermal imaging cameras that some companies produce, such as FLIR systems, which you and I have spoken about, have the ability to check temperature with a higher degree of accuracy. In addition, they can control for environmental elements that some of the other systems don't control for. It's a difficult situation where you have people running around with these temperature check guns that they purchased at their local five and dime, to put it mildly, and relying on them in determining whether or not somebody actually has an elevated temperature. The CDC guidelines use a temperature setting of 100.4 as an indicator of a potential coronavirus situation. But unfortunately, somebody could easily wake up in the morning, not feel well, take 2 Tylenol, and lower their temperature, and then we don't know whether or not there's actually any accuracy with it. The other issue that temperature checking raises, of course, is confidentiality. Because while employers now have been permitted to take temperatures, before that was considered an impermissible medical examination that was not allowed, they still have the obligation to maintain confidentiality.
That's where HIPAA applies.
Right, HIPAA and other confidentiality regulations with regard to the Americans with Disabilities Act and somebody that might have an illness. I actually read an article that was kind of funny the other day about somebody advertising a temperature check kiosk that could be put in place in an office building where a red siren would go off and in the event that somebody had an elevated temperature. Now, we're laughing because that just, to us who deal in this on a professional level all the time, seems completely absurd. But, it presents a serious issue because then automatically somebody's confidentiality is breached.
There's a lot of stupidity in the world, and heaven knows we all run into it. Well, I want to thank you for coming in and taking a couple extra minutes to talk to us about this. For those of you that are watching this online, we'd like you to come to theriskadvisor.com and watch the podcast, see episodes like this, and get to listen to the entire podcast in its entirety, where we really get into a lot more of the specifics. So on behalf of Helen, Rella, and Jim Henry, my co-host, and myself, we'd like to thank you for watching, and we hope you tune in real soon. Thanks.
Thank you.